Hi, my name's Debbie Parkinson. I'm a Tenancy Enforcement and Support Manager based at our Chorley office. I'm here today to talk to you about the new Anti-social Behaviour, Crime and Policing Act, which came into force in 2014. When the current government came into power, they reviewed the existing anti-social behaviour legislation and decided that it was too unwieldy, with too many powers that overlapped and a lack of cohesive action between the various agencies. They felt that legal action took too long to obtain, that the system needed a general overhaul in order to make sure that agencies were putting victims first. So, here it is. You can see it's quite a hefty piece of legislation, but luckily for us, the majority of the changes affect the way that the police and the local authority work. We're really only affected by two parts of the legislation, those which refer to injunctions and possession. Let's have a look at the Adactus picture. In the last 18 months, we've dealt with almost 2,500 antisocial behaviour cases. The majority of these are dealt with without the need for legal action, using various other tools and powers available to us, such as warnings, mediation, and in some cases, referrals for support. However, in around 5% of our cases, we have taken some form of legal action. The injunction is our most used form of legal action, with nearly 90 orders obtained in the last 18 months. It's proved to be a quick, simple, cheap and effective tool for managing antisocial behaviour in cases where we feel residents need urgent protection due to threatening or aggressive behaviour, or in cases where the nuisance is continuing despite other action. The main changes to injunctions are that they can be used against young people between the ages of 10 and 17, and that the orders can now include positive requirements. At the moment, injunctions only contain prohibitions, so they tell people not to do something. For example, not to use or threaten to use violence against your neighbour. When this new part of the legislation comes into force, hopefully in January, we'll be able to request positive requirements in order to try and address any underlying issues. For example, in many of the cases that we deal with, the perpetrator has an alcohol problem which contributes to their nuisance behaviour. In those cases, we could ask that they attend an alcohol awareness course or even rehab where appropriate. As an ASB practitioner, I was quite excited when I heard about this next change, as it's been introduced in order to speed up the eviction of our most antisocial tenants and so bring a faster relief to the victims of ASB. It's a new absolute ground for possession in cases where ASB or criminality has been proved in another court. Let me explain. Prior to October this year, every application for possession is heard by a judge who considers the evidence and decides whether it's reasonable to grant a possession order. In some cases, this can mean decisions which, to us and to our witnesses, might seem unreasonable. Basically, this new ground means that the court must grant possession if one of 5 conditions is met, and it almost takes the judge out of the equation. So what are these conditions? The first and second are if there is a proven breach of an injunction or a criminal behaviour order. The third condition is if someone is convicted of a serious criminal offence. I've listed some of these on the slides, but the legislation also covers some sexual offences, those including the use of offensive weapons and some drugs-related offences too. The fourth condition is if someone is subject to a premises closure order. And the final condition is if there is a proven breach of a notice for statutory nuisance. A point to note here is that these conditions don't just relate to our tenant, they also cover people who live with them and any visitors. So, a pretty powerful tool which, if it works, should speed things up and avoid the need for any court hearings. However, there is a caveat to what sounds like a brilliantly quick and effective way of dealing with ASB, and it's called human rights. We'll talk more about this a little later. The government has also extended our current discretionary possession ground for antisocial behaviour to include a section where, if the tenant or a person who lives with them or visits their property causes a nuisance or annoyance to the landlord in connection with their housing management function, then we can apply for possession. Examples where we might use this could include where a resident is abusive towards staff or a contractor, or where someone's behaviour prevents an officer from visiting or carrying out essential works. The riot ground is the government's response to the widespread rioting which occurred in 2011. Essentially, if there's another riot in the UK and a tenant or someone living in their property is convicted of a serious offence which took place at the scene of a riot, then we could apply for possession. So, what are the strengths of this new legislation from our perspective? I talked earlier about mandatory possession and how it could speed the process up in some of our serious cases. It can take up to a year and sometimes longer from issuing an application for possession to obtaining a possession order. And in some cases, we don't always get the outcome that we feel is warranted. In the last 18 months, we've applied for possession in 5 cases where the tenant has been convicted of a serious criminal offence. In one of those cases, we weren't given an outright possession order, that is, an eviction order, and the tenant is actually still living at his property, despite spending 3 years in prison after being found guilty of threats to kill 2 people. Perhaps we would have obtained an eviction order under the new legislation, who knows? The other advantage of the new mandatory ground is that it avoids the need for witnesses to attend what can be a very stressful court hearing. In terms of positive requirements, it's hoped that these will bring about an underlying change in the person's behaviour and therefore help them to address their antisocial behaviour. In 11 of our injunction cases, there was a clear link between the tenant's drug or alcohol misuse, and so we could have requested a positive requirement for them to attend drug or alcohol counselling. In 2 of those cases, the tenants were subsequently evicted, and we have or are now in the process of applying for possession against 3 others. It's possible that eviction could have been avoided if these people had been forced to accept the support that they clearly needed. We've talked about the potential advantages. Let's look at the possible disadvantages. When there are changes in legislation, solicitors often use this as an opportunity to make challenges to any applications that we make, and this could mean increased costs. So, for example, we might find ourselves challenged by a solicitor if we haven't included a positive requirement in an application for an injunction. In terms of the mandatory possession ground, although on the face of it, it looks like we can evict a tenant easily if the condition is met, we must still consider the human rights implications for any chance of a successful outcome. We need to consider whether evicting a person is a proportionate means to achieving a legitimate aim. What are we trying to achieve by evicting them? Is it fair, and can we justify our decision? For example, what if a visitor to our tenant was convicted of seriously assaulting a neighbour at the tenant's barbecue? The people he was visiting are a family with 2 small children. Is it reasonable and proportionate to evict this family? What do you think? Human rights challenges are more likely to succeed in exceptional circumstances, so are likely to involve occupants who are vulnerable as a result of mental illness, poor health or disability. In practice, the court should summarily dismiss cases without a hearing, where there is no obvious merit in an Article 8 defence. But judges are sometimes reluctant to do this, and the case does end up in a hearing, which defeats the objectives of the legislation. The other potential problem with mandatory possession is that it's an all or nothing piece of legislation. So essentially, if we apply for it and we lose, we end up with no court order at all. This, of course, could be devastating for the victim. Finally, in terms of positive requirements, we may need increased resources in order to manage these. For example, in some areas, the services our tenants need are not always available, so we may have to fund them. So, the new legislation contains potentially useful new powers for housing associations. However, at this stage, it's difficult to tell whether these will help us to deal with antisocial behaviour more effectively. Only time will tell. I hope you found this presentation useful. If you do have any questions, please speak to Chris Smith, who's available at the meeting. Thank you.